If you get hurt on somebody else's property, you slip in a store, or you fall on a broken stair, or you trip over something in a dark parking lot, by the time most people call a lawyer, they've already hurt their own case and they don't even know it. Not because they did anything wrong, because nobody told them what to do in the first few hours. So today, Mallory and I are going to walk through exactly what to have ready before you talk to a lawyer, including us, and the quiet mistakes that cost people thousands.
Yeah, here's the thing that makes slip and fall cases different from almost any other injury case. The evidence vanishes faster than you'd ever expect. That spill that you fell in, mopped up within minutes. The ice, melted by the afternoon. The broken railing or the burned out light, quietly repaired before you're even out of the emergency room. And in premises cases, the whole question is whether the property owner knew or should have known about the hazard and failed to fix it. If the hazard is gone and nobody documented it, that question gets a lot harder to answer. So the strength of your case isn't just that you fell, it's what you can prove about why you fell and whether they should have prevented it. The good news is that none of this is too complicated. You just have to know how to do it. So let's start with the thing that almost everyone skips. Rick?
Yeah, and that's the incident report. Before you do anything else, write down everything you remember while it's still fresh. Not for the lawyer, but for yourself. You date it, the exact location, which store, which aisle, which entrance, the time of day, what the lighting was like, what you slipped or tripped on, whether there was any warning signs, and just as important, whether there wasn't anyone. What employees said to you, what actually hurt, and when it started hurting. People think they'll remember, but I promise you, 4 months from now, when an insurance adjuster asks you to describe exactly what was on that floor, the version in your head will have softened at the edges. The version you wrote down the day it happened, that one's gold. Type it, write it, leave yourself a voice memo. I don't care how you do it. Just capture it right then and there, and then don't touch it. And while you're capturing your memory, the clock is already running on the physical evidence.
Yes, and this is the most important step in a premises case specifically, and you usually only have one shot at it, and that's to photograph the hazard before anyone cleans it up. The spill, the puddle, the ice, the cracked step, the missing handrail, the dark stairwell, whatever it is that caused your fall, get the whole scene and get close-ups. And photograph what's missing too, like Rick said. If there's no caution sign or no cone or no warning, capture that. If you're too injured yourself, have a friend or a loved one take photographs as soon after the incident as possible. Then photograph yourself as well, photograph your injuries. And again, over the next several days as bruising might develop, because day 1 and day 5 look very different, right? And keep the shoes and the clothes that you were wearing exactly as they were. If you can, don't wash them, don't throw them out. The store will love to argue that you were in flip-flops or heels, it was your fault for the fall, and your actual shoes can shut that argument down. And here's the other piece. Almost every business has security cameras, and that footage records over itself, often within days. You can't grab it yourself, but you can note that the cameras were there and tell your attorney immediately, so we can send a letter demanding they preserve it before it's gone. Which brings up the next thing that people forget even exists, the official record. Rick?
Yeah, and before I get to that official record, I just wanted to point out 2 things that Mallory said. One is the reason why you photograph what you fell on is because we need to prove that there was a dangerous condition. And if we can't identify what it was that you fell on, we're going to have a tough time proving that it was a dangerous condition. And the second thing that she brought up that I think is very important is this preservation letter that we send out. We need to get that out fairly quickly to the claims officer so that they can preserve that video, because oftentimes they record over it. And that could be the most important piece of evidence. So step 3 is getting the official documentation. So if you fall in a store or in a business, you report that before you leave. Ask them to fill out an incident report. Everybody has one. Get the manager's name, get the report number. That document created by them in the moment can become one of the most important pieces of your case. And we've seen this time and time again. When they get that incident report, that documentation also clues them in that they should preserve the recording as well. And if anybody saw it happen, get their name and number right there. Witnesses are the first thing to evaporate. Another customer who'd happily back you up on day 1 is impossible to find the next week. But be careful, because not all documentation helps you. When the property owner's insurance company calls, and they will call fast, sounding very friendly, and they ask to record a statement, you're not required to give one before you've talked to your own attorney. Be polite, get the claim number, tell them that your representation will follow up. That one sentence protects you more than people realize. And speaking of things people get wrong, the next one is the single biggest case killer we see. So I'll hand that off to Mallory.
Yeah, and I want to talk about this, but first I want to mention something about witnesses, like you said, Rick. Something that we see a lot is that people will rely on the police or EMTs to get the information from witnesses that were there. They'll say, oh, of course, this person saw my fall and they're helping me afterwards. And so, of course, the EMT is going to get their information, but that does not always happen. In fact, oftentimes it doesn't at all. And so don't rely on someone in official uniform to do your documentation for you. Make sure you get that information for yourself. Lost witnesses are really difficult to find, nearly impossible if you don't get their information on that day.
Yeah. And how many times have we heard later on, did you get a hold of that witness? And this is like a year later. No, because they're gone.
Yeah. And I see it even in the intake when it's only been a week. It's even at that point, it's just so difficult to find people when you don't even have their name or phone number, right? So yeah, and going back to what Rick was saying, the biggest case killer, right? You need to get checked out and do it early. Go to the doctor, even if you feel okay right after the accident, after the fall. Adrenaline hides a lot. And with falls, especially, some of the worst injuries that result from a fall to your back, your wrist, a concussion maybe, those don't always show up fully in the first day or two. But when a doctor documents your injury close to the fall, that creates a clean line connecting the two. If you wait 3 weeks and the property owner argues your injury came from something else entirely, that gap makes it harder to argue that the injury came from that day. And so then this is a big one. Follow through also on your treatment. The fastest way to weaken a real valid injury claim is having a gap in medical treatment. You start physical therapy, you start to feel a little better, life gets busy, and you stop going, but you're still injured. The insurance company will point to that and say, see, it couldn't have been that bad. They stopped going to physical therapy. So keep your appointments, keep every bill, every prescription, every discharge paper. That paper trail is the value of your case, which is exactly what Rick will talk about next.
Yeah, which is step 5. You track every dollar. And that's important because you want to start a folder, whether it's a physical one or a digital one. You want to put everything in it, your medical bills, your pay stubs, a note from your employer showing the work that you missed, any other evidence like out-of-pocket expenses, medications, like if you purchased a brace or crutches, if you needed a ride to an appointment, even your mileage to and from treatment can count. And having it all organized in one place is very helpful, especially if you give it to a lawyer. People dramatically undercount what they're owed because they never wrote it down. And how hard is it to remember if your claim goes on for 6 months or even a year or more? Therefore, they settle for a number that only covers the obvious stuff and they quietly eat the rest. So don't make it a guessing game, make it a list. And there's one modern mistake that can undo every single thing we've talked about. Mallory's going to close us out on that one.
Stay off of social media about your fall. This one, no posts about it, no feeling great today photos or venting about the store even. We've seen this happen in cases of ours where well-meaning, really injured clients post something and it completely derails their claim. It makes it really difficult for us to argue against it. The other side, the insurance provider for the store or the property owner is going to look at your social media and a single photo of you out and about will get twisted into this person looks fine to me, right? And here's the trap on the other side. Don't go deleting old posts either, right? Because that can look like you're destroying evidence. And if those are requested in evidence, they're going to find them even if you delete them. So don't delete anything. The move is simple. Go quiet, save your own texts, emails, messages about the fall, and leave everything else alone. So once you've done all of this, Rick will walk you through exactly what to bring when you finally sit down with an attorney.
Yeah, so here's the checklist. There's 6 things. 1, your written timeline. And when you write that, make sure to put attorney-client privilege or work product on it. 2, your photos of the hazard, your injuries, and your shoes. 3, the business's incident report, the manager's name, and any claim number.
4, any insurance information that you have, including your own health insurance, because how the bills get paid by insurance matters early on. 5, you want to bring your medical and financial documents. Even if it's in a messy folder, take that folder in. Messy is fine. We'll organize it. And 6, bring your questions. Write them down beforehand because the moment you sit down, half of them vanish. Ask how the fee works. Ask about how we can help with your treatment. Ask what happens next. A good attorney will welcome every one of these questions.
Yeah, and that's so important to write your questions down because there's been so many times when they come and they sit down and they said, I had a lot of questions, but I forget now. So writing them down, or you can always call afterwards as well.
Of course, yeah, but writing them down is
Yeah.
helpful because sometimes when you sit down and you're talking it out, it's hard to talk about these things. It's a traumatic fall. Oftentimes, people are really badly injured afterwards. That can
Yeah.
do weird things to your brain, so have a list.
Yeah. And if you do those things, then you walk into that first meeting, you're in control. You're not playing catch up. You don't need a law degree to protect your own case. With a slip and fall, you just need to start before the evidence gets cleaned up.
Absolutely. And if you want to hear about the other side of this, the reasons property owners use to deny these claims and how they'll try to blame you for your own fall, stick around, keep listening. We'll talk about that in a future video.
Yeah.